Okay, so another term that is thrown around a lot in education is fair use. So I've had a
Sure.
number of educators tell me they can use something because it falls under fair use. So I wondered if we could tackle that one a little bit. Jim, could you clarify what does fair use actually mean, and then again bring that specifically down into educator world, how it applies?
Okay, so fair use is defined in the copyright statute. And essentially, if you infringe a copyrighted work, and when I say infringe a copyrighted work, the copyright statute says upon the granting of a copyright in a particular work, whatever that work may be, it might be a story, a play, a song, a photograph, a motion picture, etc. Whenever you are granted a copyright in a work, you are granted a bundle of rights with respect to that work that you are entitled to enforce if somebody were to commit an action that was within those bundle of rights. The
Okay.
one that everybody knows about, obviously, is copy it. You can't copy a copyrighted work. There are a number of rights, and these rights are all delineated in Section 101 of 17 U.S. Code. 17 U.S. Code, Title 17 of the United States Code, that's where all of these copyright laws are listed. Uh, and like any law, there are gaps within the language of the law, which is why we have the Supreme Court. So the courts determine, okay, well, what does this mean in relation to this particular set of facts? But in any event, getting back to the original question, so uh, if you violate one of the rights that are owned by the copyright owner, you are a copyright infringer. Then the statute says, however, under certain circumstances, if you can prove these circumstances exist, uh, you will not be deemed liable for the remedies that the statute permits to the owner of the copyright upon a violation of one of these rights. And that portion of the statute is called the fair use provisions, and it's come to be known as the fair use doctrine. And there is a specific listing of the types of things that a court would consider to determine whether this is a quote unquote fair use of the copyrighted material in this particular instance. So these determinations are, uh, there's no easy button to push. These determinations are very fact specific. And so typically what happens if you violate a copyright, the owner of the copyright must ascertain that violation in a court of law. The owner of the copyright must bring a lawsuit in federal court. Only federal courts have jurisdiction over copyright
Oh,
cases.
interesting.
Uh, and they must allege a violation of one of the rights of copyright. And then the alleged infringer would have to prove that they didn't do it for some reason. In other words, one of the specific allegations that must be made in order to prove a claim of copyright infringement was missing. Or if all of them are present, then one of the potential defenses available to the defendant is, yes, I did what would ordinarily be an infringement of the copyright. However, those acts should be deemed to fall under the fair use doctrine of the statute, and therefore there's no remedy that can be obtained against me. And there are four delineated factors that are considered by the court when these situations arise. Uh, and I'm looking at them. I have a little cheat sheet here.
That's
Um,
okay.
uh, there's two that are probably more important than the other two. Uh, One of the most important ones that a court will look at when one of these lawsuits is filed and the defense of fair use is raised is, uh, what did the action of the alleged infringer, what effect on the copyright owner's use of its own work would that have? In other words, did it deprive the copyright owner of something significant that otherwise the copyright owner would be able to do? For example, if you are a songwriter and somebody records your song and is making a lot of money off of it and is not paying you, uh, that might be a very substantial thing that would not be deemed a fair use.
Yeah, makes sense.
Typically, if the use that is made or the violation of the right of the copyright owner uh, is something that has significant commercial value that is now deprived from the owner of the copyright, uh, it's very unlikely that that will be deemed a fair use.
Right.
So that's one of the more important
Okay.
of the factors.
Okay.
Uh, Another related factor that maybe is secondarily most important is uh, what was the violation of the right? What right was violated of the copyright rights that are accorded to the owner? And so, what is the purpose and the character of the use that is being made by the alleged infringer? Um, is it commercial? If it's commercial, the likelihood that you would be deemed to have be entitled to the fair use defense is pretty low. One of the other factors is the nature of the copyrighted work. Um, is it something that is of limited commercial value, and you have now taken that commercial value from the owner of the copyright uh, by virtue of what the nature of the copyright work is? Then that is unlikely to be deemed a fair use. Uh, and then how much of the copyrighted work has been used relative to the work as a whole? If it's just snippets here and there, that's one thing. But if you're quoting large swaths of whatever the copyrighted work is, if you're taking a movie and showing a lot of it uh, in a commercial way, obviously that's not likely to be deemed a fair use. And even if you're doing commentary and you're showing parts of the movie that are the reason that people are likely to go see it because they want to know what happens, and then you're showing it on TV, that's a problem, probably. I don't know of a specific instance of that, but based upon my thinking anyway, that's
Absolutely.
going
Yeah.
to be a problem.
Definitely makes sense.
So that is something that is very much in the I would say the ordinary person thinks that they know what a fair use is, and I think, to be fair, it's because the statute itself says it lists certain things which tend to be a purpose that might fall within fair use, but that's not the end of the story. And so one of them is teaching. Okay. It specifically mentions teaching. Uh, and it mentions it and it puts in a parenthetical, including multiple copies for classroom use. So basically, it almost invites teachers to copy things and think that it's fair use. Well, it might be, depending upon all of these other factors, but it's sort of a Trojan horse there, if you will, that it sort of suggests to teachers that, okay, because we're a teacher, we can pretty much do what we want. That's not the case.
Right.
And there are situations where, uh, what you might have thought was going to be a fair use because of the amount of copying that was done, because of the effect it had on the underlying work, because the copyright owner was not able to sell as many as they did before, uh, you're going to be in trouble if they
Right.
find out about it and they bring you to court. I guess from the standpoint of a teacher, you might want to be more familiar with the fair use provisions and ask yourself some of these questions. Okay, if I make this copy and if I do this with the copy, in other words, if I make a copy and then I start giving them out to all my students, they don't have to buy the book. Is the publisher going to be happy about that? Not necessarily, especially if the publisher's been selling the book to your school, you know, and all of a
Exactly.
sudden the sales go down. You're
Right.
not buying anymore. That's something they might look into, and so you might want to think about that.
Right.
A fair number of the cases that we get in my firm are cases where people have copied things off the internet, like an image of some sort. And there are photographers that that's how they make their money, by selling the photographs they make. Uh, and they there are organizations that make themselves available for a fee to photographers, and they will search the internet for the photographers' photographs that are being used without a license. And those organizations have attorneys on retainer that will send, the infringer a letter and a demand for, a couple $1,000s, $5,000, whatever it is. And so once they get one of those letters from an attorney, then they go looking for their own attorney to.
Of
And
course.
so we get a fair number of those.
Yeah.
As long as we're on the topic, I would just caution that. So the term of copyright is very long. And so if you're getting a photograph of something that's of recent vintage, chances are there's a copyright in it.
Correct.
And so make sure that you got permission from the owner of the copyright before you start making copies and distributing it on your website or whatever.
Yeah, for sure.
Because likely as not, that's somebody's copyrighted image. And if it's a photographer, you're liable to get one of these letters. And
Absolutely.
yeah.
So something I heard said quite a few times, a word that was used was might. That might count. It might not. And I think it's really imperative that we as educators take heed to that, because it is, like you said, it's up to the judge, when they look at it, to say, okay, well, to decide whether or not that might fall within that. But this is where we can go above and beyond to say, above reproach in this, to stay well within the bounds of that. So I think that was one takeaway. That was a great explanation, because fair use is big. It's not just a golden ticket for everybody to do what they want. There are a lot of things to consider there. And then that word might is really, really important, because it might fall under fair use, it might not, and we need to make sure we are well within the bounds. Brought to you by BJU Press.